The government is calling it a bold reform package, the most significant changes to the Native Title Act since the Mabo ruling 20 years ago. Tax on native title claims will be scrapped and efforts are being made to speed up the negotiation process. But the government has stopped short of giving Indigenous groups what they really wanted, a change to the way they prove continuous connections with the land. Nada Gilmore reports.
Indigenous groups have been waiting a long time for these changes to native title. Despite the huge gains as a result of the Mabo ruling 20 years ago, there's been growing frustration at the time it takes to settle claims, some cases taking up to 15 years. The Attorney-General, Nicola Roxon, has used a speech at the National Native Title Conference in Townsville to announce the government's plans. In future, native title payments will be tax-free, meaning they'll be treated like other forms of compensation. There'll also be greater legal powers to ensure groups negotiate in good faith, and land use agreements will be altered, all aimed at less technical, more flexible claims.
The government will work with stakeholders to allow parties to agree to put aside issues of historical extinguishment and parks and reserves. Our discussions may even identify a wider application of this concept if there is broad support for change. Time and money will be saved by parties forming agreements over native title rather than just automatically resorting to litigation.
Despite pressure, the changes won't reverse the onus of proof, which requires traditional owners to demonstrate a continuous association with the land.
I do know, of course, that there are people that have argued for more radical changes. But incremental change is lasting.
The Attorney-General is promising close consultation with all stakeholders before legislation is finalised.